and requires explanation. Counsel posited that what constitutes liquidated claim has been defined by Apex Court in a plethora of cases, covering both the claims in summary judgment and claims under the undependent list procedures, which are similar and have exactly the same principles applicable to them. In support of these contentions, counsel refers to the cases of Ebong versus Messrs. Obono and Associate. Counsel also refers to the case of Mikra International Agency Limited versus AZ Petroleum Products Limited, where His Lordship Loloku Sodifo defined liquidated sum as follows. The meaning of a liquidated, I quote, the meaning of liquidated money is also settled having regard to the numerous cases decided under the independent list procedure. Liquidated money demand means a debt or specific sum of money usually due and payable, and its amount must already ascertained or capable of being ascertained as a matter of arithmetic without any other or further investigation. Counsel also refers to the cases of Odume versus Inachi and that of Maja versus Samoros, where the Supreme Court's FAPB JSC retired said the sum must be arithmetically ascertained without any further investigation. It is also with reference to a contract. The parties to the contract must have mutually and unequivocally agreed on a fixed amount payable on breach. The agreed and fixed amount must be known prior to the breach. Counsel asks the question, can it be said that the claimant's claim in the main suit is liquidated? Counsel answers the question in the negative. The defendants contracted the claimant as its medical consultant on a monthly honorarium of 250,000 naira for a period of 2 years, commencing from 1st of March 2014. Then the contract was renewed to take effect from 15th day of June 2017 for another 2 years and no further. Counsel submitted that the claimant's claim is for 4.5 million, which is deduced from documents annexed, covers the period of 2017 and 2019, but the claimant was not contracted by the defendant for the entire period of 2017 or the entire period of 2019 and has not shown the specific months owed him or how he arrived at the sum claim in the main suit. Counsel argued that this leaves discrepancy as to the amount claimed because the claimant is now required to explain certain matters with regard to his claim. Counsel submitted that the amount cannot be said to be liquidated, not being arithmetically ascertainable without any further investigation. Mutually and unequivocally agreed to pay the claimant that amount not to be known prior to the termination of the claimant's contract. Counsel asked the court to hold that this suit is unfit to be heard under the summary judgment. It is also the submission of counsel that the claim for interest is outside the contemplation of the summary judgment procedure and just arguable. Counsel contended that the claim for interest is far from being within the contemplation of the rules of procedure and practice regarding independent list vis-a-vis a summary judgment procedure. On this submission, reliance was placed on the case of Ogbonna versus Ukaibu and that of Uber and another versus Fidelity Bank PLC, where the Court of Appeal reiterated the principles above and held that there was no iota of evidence establishing the respective parties were at idem regarding the rates of interest and charges accruable from the facility granted by the respondent to the applicant. It is the submission of counsel that the claim for interest being outside the contemplation of the summary judgment procedure, the claim of the claimant for 15% interest is unascertainable and cannot stand. It is the submission of the defendants having contended that the claimant's claim is unliquidated and require further investigation, as there is nothing to show how the claimant arrived at the sum now claimed. A triable issue or depends on the merit has been put forward. On what constitutes triable issue, counsel refers to the case of Alhaji Hassan Khalid and Al Nassim Travels and Tours Limited and another, where the court stated thus, quote, a triable issue is an uncontroverted allegation contained in the defendant's affidavit which cannot and should not be given a wave of the backhand, and which requires further investigation by the court to unravel the veracity or otherwise of same situation that would give rise to tribal issue includes the existence of one, dispute as to facts which ought to be tried, or two, real dispute as to the amount due to the party making a claim, which would necessitate taking an account to determine the account, or three, reasonable ground, or a probability of a bona fide defense. Counsel refers to the case of GMO Ngora and Sons Company Limited versus Afam Akputa Esquire, and the case of Babington Ashaye versus EMA General Enterprises and SPD Nigeria Limited versus Archeojoy Nigeria Limited. Counsel continued his submission that there is no way claimant can be awarded without some explanation, which can only be done by hearing on the merit. The circumstances are thus such that warrant striking out of the claimant's motion as they require that this suit be set down for hearing on the merit. On this submission, counsel relied on the case of Callistus Obitunde versus Onyeso Community Bank Limited. It was also referred to Omoniame versus Holding Limited versus Shonebe Enterprises Limited and Macaulay versus Nal Merchant Bank. According to counsel, all that the defendants are required to prove in the circumstances is that the claimant's case requires some explanation. This established principle of law was reiterated by the Supreme Court in the case of Thor Limited versus FCMB Limited. To counsel for the defendants, the duty of trial court is in an application for summary judgment where counter affidavit has been filed by the defense, is not to see whether the defense being put up would succeed or whether the defense has been proved or established. The duty of court is only to look at the facts deposed therein in order to determine whether there is a prima facie defense which shows a tribal issue. It is not necessary for the court to consider if the defense is meritorious or not, having regard to the abatement in the affidavit and the documents, if any, exhibited. The duty of court at the stage is to simply look at the facts deposed in the affidavit to see if those facts can prima facie afford a defense to the claimant. See the case of Ishizawa versus Jeswani and the case of Joseph Dean versus Okose, Osoko, and Okobo, relied by the claimant. In concluding, by the defendant, in concluding his submission, counsel submitted that for all the reasons given, the claimant's application for summary judgment should be struck out and the matter be set down for hearing. In reply on points of law, counsel for the claimant pointed out that in the entirety of the processes filed, the defendant respondent did not file a single document to legally counter the claimant's applicant's claim for non-payment of his emolument. It is the submission of counsel that, citing several cases in order to argue that the claimant's applicant's motion does not contain any monetary reliefs. The claimant's application did not state the period he was owed. Is all attempt to explore the meaning of liquidated sum, whether award of interest is contemplated under the summary judgment. Attempt to beg the question. Counsel submitted that the cases are authorities for what they decide and no more. In support of this view, reliance was placed on the case of Modibo versus APC. Counsel contended that plethora of cases are not on all fours. The plethora of cases cited by the defendants are not on all fours with the case at hand, hence are inapplicable to this case. Counsel further submitted that the claim contained in paragraph 6 of the affidavit in support borders on the main on arrears of 4,500,000 is ascertained and capable of mathematical exactitude. This fact was admitted by the defendant, hence their contention on how claimant arrived at such figure. Since the defendant have admitted that the sum of 250,000 will equals to 18 months, counsel relied on Exhibit TOFA 1 on this submission. Counsel also submitted that rules of court are not same. NICN being specialized court in order 16 rule 1 does not stipulate an applicant must state figure sought. The reason is not far-fetched. Under the same rule, the application is for summary judgment for originating process. In this case, the complaint before the court. It is submitted rather than produce documentary evidence of payment of claimant's emolument. The defendants barely gave blanket denial. Counsel further submitted that in the case of Kembu versus FCMB PLC 2022, the court stated that further bare denial of liability cannot amount to reasonable defense in a claim for debt, which is admitted. The burden shifts on the defendant to show how the debt has been liquidated. Contrarily, the claim in paragraph 4 of the counter affidavit is of no moment as same is not unsubstantiated by payment document and how same was paid into the claimant's applicant salary account. Exhibit TOPA 1 buttress these submissions that the defendant have not paid the claimant the agreed emolument as herein claimed. Counsel submitted that the defendants have not shown good defense as there is no evidence that they have paid the agreed emolument. Their counter affidavit is same which with their pleadings showing no defense, as the law requires the defendant to produce document. Counsel relied on the case of Saleh versus Bank of the North to buttress his submission. On interest, counsel argued that it is part of contract that where a person is indebted to another person and he keeps the money, such money should attract interest. It is in event quite disheartening when from Exhibit 241, it is shown that the defendants have never paid the complete agreed sum of 250, but 220 plus. A claim for interest is at the discretion of the court, as same is ancillary to the claim giving rise to the cause of action, which is indebtedness of the sum of 4.5 million. Counsel submitted that claim for interest is within the realm of consequential order, which the court may grant or otherwise refuse. In concluding his submission, counsel contended that the defendants had failed to show why they should be let in to defend, having not unsuccessfully controverted the evidence of the claimant in the main that he is owed the sum of 4.5 million as emolument for from June 2017 to January 2019. Counsel pressed the court to enter judgment in favor of the claimant applicant for his complaint in support of this submission reliance was placed on the case of Chabasaya versus Anwasi and Section 123 of the Evidence Act 2011. According to counsel, the attitude of the defendants tantamount to an unfair labor practice, which counsel praised this court to correctly enter judgment accordingly in favor of the claimant. On this, counsel relied on the case of Oboli Shiga versus BSICE 2015, 10 Nigerian Kilolo Report, Part 775, and Section 115 of the Labor Act, Laws of the Federation of Nigeria, 2004. Counsel urged the court to discountenance the submissions of counsel for the defendants and enter summary judgment in favor of the claimant. Court decision. I have considered the processes filed in this case, the written and oral submissions of counsel for both parties. As pointed out earlier in this application, this application is framed for summary judgment as provided for under Order 16 of the National Industrial Code Civil Procedural Rule. In the circumstances, it is apt at this juncture for proper appreciation to reproduce the provisions of Order 16 of the rules of this court, which provide as follows. 1. Where a claimant believes that there is no defense to the claim, an application for summary judgment supported by an affidavit stating the grounds for the belief shall be filed along with the originating process. The application shall be accompanied with statement of facts, any exhibit, and a written briefs. 2. A claimant shall deliver to the registrar as many copies of all the processes and documents referred to in Rule 1 of the order as there are dependents or respondents. 3. Service of all processes and documents referred to in Rule 1 of this order shall be effected in the manner provided for under these rules. Rule 4. Where a party serves with processes and documents referred to in Rule 1 of this order intend to defend the action, such a party shall not later than the time prescribed for defense file A statement of defense, B, document to be used in defense, C, a counter affidavit and a written brief reply to the application for summary judgment, and D, written statement on oath of all the witnesses listed to be called by the defendant, other than witnesses to be subpoenaed. Rule 5, sub-rule 1 provides where it appears to the court that a party has a good defense and ought to be permitted to defend the claim, such party may be granted leave to defend. Sub-rule 2, where it appears to the court that a party does not have a good defense to the court may thereupon enter judgment for the claimant. Sub-rule 3, where it appears to the court that the defendant or respondent has a good defense to part of the claim, the court may thereupon enter judgment on that part of the claim to which there is no defense and grant leave to the defendant to defend that part to which there is a defense. 6, where there are several defendants or respondents and it appears to the court that any of the defendant or respondent has a good defense and ought to be permitted to defend the claim, and other defendants or respondents do not have a good defense and ought to not to be allowed to defend the claim, the former may be permitted to defend the claim. The court shall then enter judgment against the latter. Rule 7, where provision is made for written briefs under these rules, each party shall be at liberty to advance before the court oral submissions to expatiate the party's written address for not more than 20 minutes. Rule 8, sub-rule 1, a party to an action may submit it to judgment in respect of any claim by the claimant and seek the leave of court to defend the part of the claim the party is contesting. Sub-rule 2, where a party submit to a party of the claimant's claim in line with sub-rule 1 of these rules, the court shall enter judgment for the claimant accordingly, and thereafter grant leave to the defendant to defend the contested part of the claim. It is clear from the above provisions of Order 16 of the rules of this court that where a claimant believes that there is no defense to his claim, he shall file an application for summary judgment supported by an affidavit stating the grounds for the belief. The application shall be accompanied by the statement of facts, any exhibit, and a written brief. Upon being served with the processes, the document referred to in Rule 1 of Order 6, the party serve if he intends to defend the suit, he shall not later than the time prescribed for defense file his statement of defense, deposition of his witnesses, exhibit to be used in the defense, a counter affidavit, and a written brief, a reply to the application for summary judgment. By Rule 5, Sub-Rule 1, where it appears to a judge that the defendant has a good defense and ought to be permitted to defend the claim, he may be granted leave to defend. Where it appears to a judge that the defendant has no good defense, the judge may thereupon enter judgment for a claimant. Where it appears to the judge that the defendant has a good defense to part of the claim but no defense to the other part of the claim, the judge may thereupon enter judgment for that part of the claim to which there is no defense and grant leave to defend that part of the defense to which there is a defense. The provisions of Section 16 of the rules of this court quoted above are clear and unambiguous. It is a cardinal rule of statutory interpretation that where statutory provisions are clear and unambiguous, the provisions must be given their clear and ordinary meaning. See the case of Buhari and another versus Yusuf. See also Attorney General of Bendel State and Attorney General of the Federation. See also Ojukwu versus Obasanjo. Under Order 16 of the rules of this court, where a party served with the processes and document referred to in Rule 1 intend to defend the suit, he shall not later than the time prescribed for defense file his statement of defense, the position of his witness, exhibit to be used in his defense, a written brief in the reply of the application for summary judgment. Where it appears to the judge that the defendant has good defense, he ought to be permitted to defend the claim. He may be granted such permission to defend. Where, however, it appears that there is no good defense, then the judge may enter judgment for the claimant. The summary judgment procedure provided for under Section Order 16 of the rules of this court is a specific and special procedure distinct from procedure dealing with originating processes commencing an action, in that no witnesses to give evidence are required. It is clear that the summary judgment procedure is targeted at speedy disposal of case where there is no defense or good defense to the claim. There are then no issues to settle. The duty of court in such a case in such circumstances is to look at the processes filed to see whether the defendants have good defense to the suit or not. It is pertinent to point out that summary judgment procedure is partitioned out to deal with undisputed and or clearly incontestable case summarily or brevi manu, and in the most expeditious manner for the purpose of saving cost and time, in contradistinction to cases put on the general cost list, which are oftentimes caught in the protracted web of litigation, which is the bane of civil litigation in this country. See the case of Sodifo versus Lemminkind. The summary judgment procedure was designed to enable a claimant recover his liquidated money claim through the instrumentality of design judicial process, which is as fast as possible and without the need to go through the rigors of full-blown trial, which are usually attendant and prevalent with processes commenced with writ of summons. The summary judgment procedure is usually and invariably employed to eliminate the delays occasioned to cases that are allowed to go through the normal routine process of hearing. In summary judgment procedure, the evidence is adduced in form of affidavit evidence, documentary evidence, annexed to the affidavit in form of exhibit, and final written address to attach to the summary judgment application. See the cases of Lewis versus UBA PLC, Tor Limited versus FCMB, Ifeanyi Chukwu Trading and Investment Ventures Limited, and another versus Onyeso Community Bank PLC, Community Bank Limited. In the instant case, the claimant, as can be gleaned from the two affidavits filed by him and the originating processes commencing suit, is to the effect that the claimant was engaged by the first defendant on temporary basis to serve at General Hospital Mary Seleso Avenue, Calabar, by the letter of 24th day of March 2014 for a period of 2 years. The claimant was in 2017 re-engaged or has his temporary employment renewed to serve for another 2 years, certain, commencing from the date of resumption. In 2021, claimant was paid part of arrears of 6,250,000, leaving outstanding sum of 4,405 million. The failure or neglect by the defendant to pay outstanding arrears of salaries made the claimant to approach this court for redress. The defendants on their part have stated that the claimant was never employed for the whole of 2017 and 2019. The appointment of claimant was for 2 years with effect from 24th day of March 2015, and the claimant was reappointed for another 2 years with effect from June 2017 and no more. Based on the facts as revealed by the processes before the court, the claimant insisted that he has shown that he is being owed the sum of 4,400,000 as arrears of unpaid honorarium / allowance / salaries from June 2017 to December 2017 to December 2018, January 2018 to December 2018, and January 2019. The claimants heavily relied on Exhibit TOFA 1 in contending that he had proved entitlement to the sum of 4.5 million arrears. The defendants have argued that the claimant has not made out a case entitling him to payment of any sum, as in the case of his application. He has not disclosed any monetary claim, and even if he has disclosed monetary claim, the monetary claim is not liquidated claim and is unascertainable or disputed, in which case the procedure adopted to obtain quick judgment is not available to the claimant, and the defendants have a defense. It is pertinent to observe here that the summary judgment procedure under the provisions of Order 16 of the rules of this court are wider than the summary procedure as obtainable under other rules of court or under the independent list procedure. The summary judgment procedure under Order 16 covers both liquidated and unliquidated monetary claims. All that is required of claimant is to convince the court that there is no defense to his claim. This means that the defendants insisting that the claimant this means that the defendant insistence that the claimant's application or prayers must contain monetary claim, or that the claim must be a liquidated monetary claim, is untenable under the provisions of Order 16 of the rules of this court. The Order 16 of the rules of this court accommodate both liquidated and unliquidated money claim, and even other claims that are not monetary in nature. While the defendant is required to convince the court that she has a good defense on the court's part, it will consider if the defendant has a defense and ought to be permitted to defend the claim. If the court found that the defendant has a good defense, permission may be granted. Leave may be granted to defend. But if, after considering the processes before the court, it appears to the court that the defendant does not have a good defense, the court may thereupon enter judgment for the claimant. And such judgment will be judgment on the merit and cannot be set aside by the same court that made it. It can only be appealed against if defendant is aggrieved to such an order or such a decision. See the case of Iron Products Limited versus SAC, reported in 1992 for Nigerian Weekly Law Report, part 238, page 734. In compliance with the provisions of the law, I have thoroughly examined the entire processes filed by the parties before the court. I must state that a combined reading of all the processes will in no doubt show that the claimant has been able to establish two employment contracts between him and the defendant. The first, he was employed for 2 years, commencing from 14th day of March 2014, while the second contract of employment was dated 1st day of December 2018, but with retrospective effect from 15th day of June 2017. This means, being a fixed term of contract, it expired on the 14th day of June 2019. In the claim of the claimant before the court as per his complaint and statement of facts, the claimant has no claim respecting the first contract of employment, which commenced on the 14th day of March 2014. The claimant's grounds borders on non-payment of his arrears of salary from June 2017 to January 2019. According to the claimant, his claim is for a period of 18 months at 250,000 per month, which comes to the total sum of 4.5 million naira. It is to be noted, all that is required for the claimant is to believe that the defendants have no defense to the action, and then the defendant's duty is to show existence of a good defense. See Order 16, Rule 5, Sub-Rule 1, Rule 7, Sub-Rule 2 of the rules of this court. The question to be considered and resolved at this stage is, has the claimant, by the evidence before the court, been able to show that the defendants have no defense to his action and is entitled to have judgment rendered in his favor, then the court will also consider whether the defendants, by their evidence before the court, have established or shown existence of a good defense or a tribal issue to be dealt with by the court. See the case of Inshizawa versus Jeswani, Macaulay versus Null Merchant Bank, Pan Atlantic Shipping and Transport Agencies Limited versus Rain Mass GmbH, and Thorn Limited versus PFCMB. See also Union Homes Savings and Loans PLC versus UBN. It is interesting to note that the claimant in support of his claim tendered only one exhibit, his statement of account, marked as TOFA 1, in the claimant's further and better affidavit, which was sworn to on the 23rd day of May 2023, to show what the defendants have not paid him, and to show that the defendant have not paid him any salary from June 2017 to January 2019. If the period of claim is calculated, the claimant is claiming payment of 21 months salary, and if the amount agreed as his honorarium salary, which he is claiming to be entitled to, the sum of 250 is multiplied by 21 months, the total amount should be the sum of 5,250,000 naira, which will be more than what the claimant is claiming. Furthermore, Exhibit TOFA 1 has clearly shown that the claimant was being paid the sum of 220,593 naira 33 kobo per month as his salary. If this amount is multiplied by 21, the total amount will be the sum of 4,632,459 naira 93 kobo. This has clearly shown that there is uncertainty on the amount, so which is the entire uncertainty as this amount the claimant is entitled to from the defendant. The discrepancy regarding the amount based on evidence before the court, which shows that the claimant is claiming for 21 months, while the claim before the court is said to be for 18 months. This situation can only be cleared when there is a full-blown trial on the issues before the court. From the letters of appointment attached to the statement of facts, which are in the case file, which the court is entitled to look at, the salary of the claimant is the sum of 250,000 per month, while Exhibit TOFA 1 shows that the actual amount the claimant was being paid as salary on monthly basis was less than the agreed amount. This means for the court to grant the amount being claimed, there is need for clarification as to the actual amount payment of as the actual amount of salary that the claimant is entitled to, taking into consideration the fact that payment of salary to an employee, whether as a temporary or a permanent employee, is based on net salary and not on gross salary. What the letter of employment shows is the gross salary of the claimant and not his net salary. In view of all I have been saying above, the existence of discrepancy regarding the salary of the claimant is claimant, which is to be paid on monthly salary, need an explanation. This has entitled the claimant to have this matter decided on summary judgment procedure as contained in Order 16 of the rules of this court, having found that the main claim of the claimant This is because a claim of salary cannot be equated with a claim of agreed amount under ordinary contracts or under ordinary contracts under the contract law. The agreed salary of a claimant is not the actual salary that the claimant at the end of the month receive as his take-home pay. As pointed earlier, it is only the net salary that is payable, which is a take-home, and not the gross salary. Having found that the main claim of the claimant to be unsuitable for summary judgment procedure, the remaining reliefs being sought on interest and damages, which are equally not suitable for summary judgment procedure, since those reliefs are ancillary claims which depend on the grants of the main relief of the claimant. Depending on the grant of the main reliefs of the claimant. In view of the foregoing, on the whole, I hereby order transfer of this suit to the general cause list for hearing and determination in line with the rules of this court. I make no order as to cost. Ruling is entered accordingly.
As the court pleases.
As the court pleases.
Yes, registrar, give me date for hearing.
My lord, November 21. 21 of November is a Tuesday.
Okay.
Milord,
You say?
would have suggested
You say what?
Yes, Milord, we have the sister case on
When? 14th of what?
November.
You know the issue is convenience for the court. That day may be congested. Registrar, check your 14th. Is it convenient?
My lord, since the matter is for hearing, it will not be convenient.
So counsel, that 21 is the best day we give you. We don't want a situation whereby we adjourn your matter and when you come, we will not be able to take you. Unless if you are ready, you are not ready for the hearing.
Noted, Milord.
This case is hereby adjourned to 21st day of November 2023 for hearing. Hearing notices to be issued and served on all the defendants. Proof of service to be kept in the case file.
As the court pleases. Milord, we are most grateful.
You are welcome. Any other case, Registrar?
No, my lord, that's all, my lord.
Okay, counsel, thank you for being with us. We have come to the end of today's virtual proceeding. I wish you all the best for the rest of the vacation.
Thank you, Milord. Same here, Milord.
Okay.